Hello, everybody, and welcome to this month's webinar on employment law. I'm Alex Solo. I'm the co-founder of Sprintlaw, and we will be today talking about all of the essential employment law things that you may want to know if you are running or working in a small business. Before we get to the content for today, just to quickly introduce Sprintlaw for those who don't know us or who are not already clients. We are an online law firm really designed to make legal simple and affordable for startups and small businesses. Unlike traditional lawyers who charge by the hour, we're a totally fixed fee service. So everything we do is quoted up front, and you sort of know what you're paying for. And we work in most areas of business law, from helping you get your company set up to online contracts, intellectual property, trademarks, consumer law, raising funding, drafting contracts, privacy, and as we'll be talking about today, employment law as well. We have an optional membership, but about 80% of our clients are signed up to it. It's a really great service, which has a low annual fee, gives you access to discounts on our services, and there's a platform as well where you can book quick calls with our lawyers, use an e-signatures tool, make your own free documents, and there's a bunch of AI features as well that help you stay on top of your legal health. And we'll be rolling out actually some pretty big improvements to it in the next few months as well. So if you are not already a member, check it out, and it could be great value to sign up. And there's a free tier as well if you want to check it out on our website as well. We've been around since 2017. We have expanded internationally and won lots of awards, and we are very proud of all of our success so far. So again, if you're not already a client, we'd be happy to have you join the Sprintlaw family. We've also just launched a new tool at scan.sprintlaw.co for small businesses. If you want to check out your website compliance, it's not really related to employment law that we'll be talking about, but it's great for privacy and other sorts of things. Head over to that website. You can chuck in your website URL, and our tool will scan your site and help you identify any issues that you might have with outdated policies or content on your website. So it's a free tool as well. And if after this webinar you have any questions about employment law or anything else, feel free to book a free consult in with our team, and we're happy to help you out if we can. And also, if you mention you attended the webinar, and there's some discounts for employment law related services. So I think we'll drop a link in the chat as well as to how to find us. So on to the content for today. We're going to be talking about a bunch of different areas of employment law, really starting with the basic obligations that small businesses have in Australia when you are employing staff. What are the different things you need to think about? We'll then zoom into the different types of employment, full-time, part-time, casual, contractor, interns. What are they all? How do they work? And what are the different requirements around that? What documents that you may need, contracts and policies, tax, superannuation, pay. How do you need to handle that for people that you're employing in your business? Workplace policies and procedures. There's workplace safety laws that we'll briefly talk about. And at the end, we'll talk about this law called the Closing Loopholes Law, which people may have seen in the news, came into force over the last couple of years and was one of the biggest changes we've had to small business law for employment in Australia in the last couple of decades, actually. So there's a lot of new legal requirements that you may or may not be aware of, and we'll cover what they are at the end, as well as some changes that may be coming. As I'm going through, we have a Q&A feature in Zoom. Do feel free to drop questions into the chat, and I'll keep an eye on it. I don't mind answering questions as I'm talking through slides. It can help add a bit of color to what I'm talking about. Otherwise, we'll also have hopefully a little bit of time at the end to go through any remaining questions. So let's begin by talking about how employment law works in Australia and what the legal framework is. So if you're an employer in Australia, on screen we have the three big things that you want to be aware of. This is sort of the basic framework. First of all, if you're employing staff, you need to comply with something called the National Employment Standards. This applies to all businesses across all industries, and it's a set of minimum standards you need to be complying with, and we'll go into that in a bit of detail in a moment. You need to provide a Fair Work Information Statement. It's basically a PDF document that the government requires you to provide to all staff when when they begin, and it informs people of the national employment standards. So your staff are empowered to know what their rights are. And then in addition, we have these things called modern award requirements. And what that means is, in additional to the national employment standards that applies to all businesses, in particular industries, there's an additional set of more specific laws that applies to, for example, restaurants for the restaurant industry, legal services award for the legal services industry, and many, many different awards. And it sets for those specific industries or work types some additional minimum standards that you have to also comply with. So if you are employing staff, you first want to be totally across the overall minimum requirements, minimum wage, and so on, and make sure that you've informed your staff about it. And you also want to be across your industry specific requirements. And that's a good way of, I think, framing what you have to do as an employer. So that's kind of the big picture. To zoom into each of those 3 points, so what is in the National Employment Standards? Well, it's got minimum conditions that everyone needs to comply with. It's got the minimum wage. There's national minimum wage. It's got maximum weekly hours that you can employ people. It's got things like accommodating requests for flexible work arrangements. If your staff ask you about flexible work, there's now minimum requirements you have to comply with in having those conversations. It's got leave requirements for permanent staff, the amount of leave that you have to give them per year, how sick leave's handled, obligations for you to make superannuation contributions, and how you handle redundancies and terminations. So people would be probably at a high level familiar with all of these concepts: minimum wage, maximum hours, superannuation, redundancies, and so on. Where it's encoded in the law is in these sort of national employment standards. And again, if you don't comply with these requirements, you pay someone less than the minimum wage, you're not making super contributions, you're not giving them the leave that they're entitled to, you would be in breach of these national employment standards and potentially could be fined for them. So you really want to make sure that you are not breaking any of these laws in the way that you employ staff and that you're across what they are. And then the Fair Work Information Statement is, as I mentioned earlier, a PDF document that you can get from this link. It's on the Fair Work website. And it's a document that you've got to give to every new employee. So, and you have to provide it to them either when they start or before they start, or if you miss those two deadlines, as soon as possible after they start. But you have to have given it to them, because it's not only the case that you have to comply with these minimum standards, you have to tell your staff that they have these rights. And this is obviously designed to educate employees on their rights and be able to call out their employer if they're not complying. So again, this is an easy thing to not do or not have built into your processes, but you want to make sure that whenever you're hiring or onboarding a new staff member, you are also giving them this document along with usually their employment contract, which we'll come to in a bit more detail later. So we've got the national standards, the Fair Work Information Statement, and then the third pillar was these modern awards. So in addition to those overall minimum requirements, I mentioned that each industry has its own award. For example, if Sprintlaw's in the legal industry, we've got the Legal Services Award 2020, which sets out a set of minimum requirements that we have to comply with when we are employing staff as well. So in addition to use Sprintlaw as an example, us complying with national minimum wage requirements for our staff and leave requirements, in our industry, there's a bunch of additional requirements about minimum wages for different types of legal work, and there's shift rostering requirements. Notice we have to give casuals when we're rostering them. There's overtime requirements and many other sub details for our industry that we have to comply with. So we have to be aware of these, and if in the way that we're employing our staff, we're not paying overtime or we're rostering shifts in the wrong way specific for our industry, we could inadvertently be in breach of our modern award. And same if you work in hospitality, there's a hospitality industry award that has its own list of rostering, shift requirements, overtime requirements, and so on. Fitness industry award, hair and beauty industry award. There's many awards. Now, a question could often be what industry is my business in? We're kind of in two industries. We are, both a health business and a fitness business. Are we in the health professionals award or the fitness industry award? The awards themselves have um, reasonably good descriptions as to who's in and who's out. But some businesses really struggle to figure out what their award is, and often you'll get legal advice. I mean, Sprintlaw often provides something called award compliance advice, and we help figure out what industry your award's in. And in some unfortunate cases, some businesses are kind of in two categories and may have to comply with both sets of awards, which can get very messy. But for most businesses, you would find that you largely fit into one of the awards. So that's kind of how it works. Um, so yeah, hopefully that makes sense. Um, so in terms of what the minimum wage is, which is one of these NES requirements, so as I said, employees must be paid at least the minimum wage as provided in not only the national minimum wage, but if there is a higher minimum wage in the industry award, then that higher minimum wage. So the absolute minimum is at the moment 24.95 per hour. But as I said, if your industry has higher minimum wages under its modern award, then the minimum wage that you pay in your industry may actually be higher than 24.95. And you've got to make sure that what you're paying staff is at least that amount. Otherwise, it would be considered underpayment. Um, so now we have different employment types, and people again would have heard of each of these different categories of employment. But I'll just go through each of them in a bit more detail. We have full-time, part-time, casual, independent contractors, and interns. So what you're always thinking about when you're hiring staff is what employment type do I want to use to engage this staff member? Do I want them to work full-time, a full load of 38 or 40 hours a week? Do I want them to work part-time, so less than that full-time load? Do I want them to be a casual staff member? So the hours they work may vary from week to week or fortnight to fortnight. Do I want them to be an independent contractor? So not actually an employee of the business. Do I want to just contract them as if they're sort of a separate business from mine? In which case, a lot of these requirements we talked about wouldn't apply because they're not an employee. They would be considered a separate business. So that is a way you can engage people as well. And do I want them to be an intern who works on a temporary basis? So these are the different kinds, and what you choose for a particular staff member will depend on your business requirements, how many hours you need them, what you can afford, how certain you are of the work. But so it's a selection choice for you as a business as to how you engage staff members. But there are some requirements which once you've chosen what the employment type is that you have to comply with. So if you're hiring full-time or part-time permanent staff, and when I say permanent, I mean they're not casual, they're not their hours aren't varying from week to week. It's regular hours, regular work. There are specific requirements under the NES that we just mentioned that apply to just full-time and part-time permanent roles. So full-time is typically around 38 hours per week, and it's when people obviously are working on a permanent basis. Full-time staff are entitled to annual leave, 4 weeks a year, sick leave, which they accrue over time. If they work with you for a period of time, long period of time, they get long service leave. They have rights to parental leave, and among other things. And the amount that they get is based on their hours, them doing their full hours of work. And so again, if you have staff working full time, you have to by law give them these leave requirements. Now, in the case of sick leave, or as we have here, we call it personal and carers leave, which is its legal name. You can require that they have evidence that they were sick and get a doctor's certificate before you pay out that leave. But if they are sick, you have to offer the sick leave up to a cap that they accrue over time based on how long they work with you. So important to be complying with those things. And again, if you're not complying, then you could be breaching the employment laws. And permanent part-time is very similar to full-time, but it's when people are working less than 38 hours. Then that can offer obviously more flexibility, um, but you have to comply with still those same entitlements on a pro rata basis. So if somebody works half of 38 hours as a part-time person, you give them half of their 4 weeks annual leave for the year will be 2 weeks annual leave, if that makes sense. So it's all proportional to the amount of part-time that they are. Um, so that's how permanent employment works. Now, casual employment is different in the sense that unlike full-time or part-time, which might seem similar to casual, it's not permanent in the sense that you may want to vary someone's working hours from week to week. And so it gives you more flexibility as an employer, potentially, because you don't have to necessarily commit to paying someone on an ongoing, regular, permanent basis. On the other hand, um, the casual employees have the flexibility to say that they can't work on a particular day. They don't have to commit to you that they're gonna accept all the shifts. So it's a quid pro quo in that sense. You don't necessarily get the certainty of their availability, and they don't get the certainty of employment. In addition, if you want to employ someone this way, um, you don't have to comply with um, the as much in terms of leave requirements, annual leave and long service leave and all these sorts of things, and sick leave and this sort of stuff. They do get some reduced leave entitlements, but it's a much lower amount of leave entitlements. However, under many awards, you have to pay a casual loading, it's called, so a higher minimum wage to casual employees. So if you're hiring someone on a casual basis, the minimum amount that you must pay them by law is often higher than if they were a full-time or part-time staff member. And that's to recognize the fact that the casuals are not getting any of these entitlements. And so, it's riskier for them. So they're entitled to be paid more. So it can be more expensive, at least from a cash perspective in the short term, for you to pay casual employees. But again, you get that flexibility in terms of not necessarily needing to commit to employing them for a longer term. Um, Now, for casual employees, not only do you have to give them that Fair Work Information Statement, there's another information statement they must be given called the CEIS, the Casual Employment Information Statement, another PDF that you can print out or email to the staff member. And again, it's meant to educate casuals on their rights too. So um, if you're not providing that statement, you can be a breach of the law. So you just want to make sure if you're employing casual staff that you are giving them both of the statements when they start to educate them about their rights. One of the new pieces of law that we'll talk about a little bit later in the presentation is um, this right to request permanency that casuals have, which was recently, it's been around for a little while, but it was recently strengthened by these closing the loopholes laws that came into effect last year. So if you're a casual, but you've been sort of regularly working with an employer for 6 months, or for small businesses with under 15 employees, that's extended to 12 months. But you've been working for either 6 or 12 months for small businesses with your one employer, the casuals can request that you convert them to permanent and that they get more longer term rights as a permanent employee, which you as a business have to consider. Now, you can refuse the request if there's a good reason. You can't refuse the request if there's no good reason. But it's not an obligation, but they have the right to make this request by law. So that makes that's worth sort of being aware of. So independent contractors is another form of employment that is often used by small businesses who want the flexibility to, not necessarily commit to long-term employment of a staff member. And also, a lot of these laws that I'm talking about, if you hire a staff member as independent contractor, don't apply. They're not considered an employee. So the framework of the NES and the modern awards and the Fair Work Information Statement, all this stuff I'm talking about, if you hire someone as an independent contractor, in general, doesn't apply. And so it can be very attractive for small businesses to go, that all sounds like so much administration. I just want to hire people as independent contractors. And it's very commonly used by small businesses as a way of engaging people. Now, it's worth being aware if you want to engage someone as an independent contractor, you're essentially contracting another business to provide services for you. So they need to have their own business number, an ABN number. They need to do their own taxes, their own tax return, pay their own superannuation. They kind of run all that stuff themselves, and you just pay them an invoice, and they'll invoice you for their labor, if that makes sense. And that's a fine way to do business. One thing to be aware of is if you have someone working for you who is being engaged as an independent contractor, but really they're acting a lot like an employee of your business. The layperson couldn't tell that they weren't an employee of your business. They're wearing a uniform, they're walking around representing a business, and they're essentially like an employee in essence. Then the law will say, I know you're trying to make this an independent contractor arrangement on paper, but we're going to view this as an employment arrangement. And if you're paying this person less than minimum wage and you've sort of got them to set up an ABN, but it's all a sort of sham to avoid having to do the admin and comply with the Fair Work Act, you can actually be faced with a situation where the law will call a contractor of yours a deemed employee, and they'll say this is not a true contracting arrangement, and the employer is liable for back pay because they never paid this person super, they never paid them overtime, they just disguised them as an independent contractor. So worth being aware of this concept of sham contracting. It's something that uh, comes up a lot for small businesses because they'll often be trying to use a contractor model to save the administration of employing people, and they run the risk of this deemed employment. Now, unfortunately, the test for whether someone is a deemed employee or whether you are sham contracting, as the law calls it, is quite subjective. And there's lots of court cases where employers were contracting people, and then a judge spent quite a bit of time considering whether this particular case was an employee in vibe or not. So it's actually it's not a clear, bright line as to when you cross into sham contracting, but it's based on what you might think it's based on with how much control do you have over how this person's working? Are they really independent, or are they just being treated like an employee and being forced to follow all of your instructions? Who bears the financial responsibility and risk? Are they, if they make a mistake, are they liable or are you liable? If it was an employee, you'd be liable. So how much risk are they actually taking on? Who provides the tools and equipment? Are they using your uniforms, your tools, your technology, or are they bringing their own stuff? If they're using yours, they look a lot like an employee. Are you requiring they do everything themselves like you would an employee, or are you allowing them to subcontract work? Are the hours of work small and irregular or very regular? And do they think this is going to go on for a long term? And so, there's a bunch of different factors. And again, we often provide advice on this when employers are concerned that they are at risk of treating an independent contractor as an employee. So you just want to be careful. And often the advice we'll give is, if the only reason you're really doing this is to avoid the admin of an employee, then you should just actually get on top of it and employ this person rather than run the risk of sham contracting, because it could be serious fines and penalties at any time in the future if this contractor comes back to you and says, hey, you should have paid me all this super. And we've seen cases of this. Small businesses have to back pay 2 years of super, and can really cause problems, and in some cases even be business ending. So you want to get on top of it if you're thinking of using independent contractors, and make sure that they truly are independent to your business. And finally, we have interns. So some of you may be considering using interns in your business. A lot of businesses do unpaid internships, which are okay to do in some instances, but there's specific laws on unpaid internships, because unpaid internships, in a way, if you're employing someone, are in breach of the NES minimum wage standards. You're not paying them anything, so you might be breaching minimum wage requirements, in addition to other requirements of the NES to give people leave and so on. So there is an exception to a lot of the laws I've just discussed for unpaid internships, but only in the case where the unpaid internship meets one of these two bullet points that I have on screen. It's a student placement, so they're doing it for course credit or as part of a degree. Or B, if it's genuine work experience, which is quite a subjective term, but essentially means that the internship is designed so they get more out of it than you get out of it. Um, so yeah, we usually advise clients not to try and rely on the second one because usually if you're getting an intern and you don't want to pay them, you're still using them for productive work, unless you're just letting them shadow and they're not actually adding much value, and maybe it's a just for their for them to get a sense of your industry, then maybe it's okay. But usually, if you want them to do something productive, we say just make sure they're getting course credit or just pay the minimum wage. Otherwise, you're at risk of breaching these requirements. So I just want to flag that because a lot of small businesses do these unpaid internships, and in my view, they can be quite risky of breaching the laws unless, again, it's for course credit, in which case it's okay. Um, so hopefully that makes sense. So I've noticed we've got a few questions in the Q&A. Is the 40 hours per week minimum working week, is that legal? So yes, it is within limits. So under the Fair Work Act, standard is for a full timer is 38 hours per week plus reasonable additional hours. So depending on what the job is, if those 2 extra hours are reasonable, then that's okay. But you've got to make sure, based on what the job is, and whether you're complying with the industry award. So there might be overtime requirements or higher rates if those hours have to be done on weekends and so on. So yes, it's the wording in the act is you can do over 38, but it has to be reasonable. And what reasonable is will depend on the job, the industry, what you're asking them to do when you're asking them to work. But yeah, that's the answer to that question. What if we pay market competitive rates? Does the modern award still apply? Yes, the award always applies. You I mean, you can pay above the award rates if that's in the market and competitive, but you can't pay below and say, well, this is what's happening in the market. I mean, that would mean that the market in general is breaching the modern award, if that makes sense. So there are some awards that have, overtime rates, penalty rates, and you want to pay an employee a higher base rate than the award, but not necessarily have to do all the maths of figuring out if they worked overtime and so on. And so you can, under some awards, sign what's called an IFA, individual flexibility agreement, with your employee and say, hey, we're not going to pay you overtime for your regular hours. We're just going to pay you a higher base rate. And we agree that this will leave you better off overall. And you agree to this as an informed employee. And so there is some flexibility to do things like that if you want to simplify the way that you pay wages. Um, uh, and again, you can just pay them an overall higher wage, which would cover them certainly for overtime and weekend work. But you have to keep records that, again, a rate that you're paying them never left them worse off than those modern awards. So the modern awards always apply, and it can't be the case that someone is getting paid less than what they should have under the award, if that makes sense, except with that narrow exception for a signed individual flexibility agreement. Then we've had a question. When an award specifies 70% annual leave loading, can employers rely on an inclusive salary clause in the contract, and what evidence is needed to show that they're not underpaid? Yeah, I mean, it's a similar answer to that question. So you can offset the award entitlements if you can prove it with records that they got paid more than they would have under the award. You basically need, in terms of what records you need to keep records of when did they actually work, so time and attendance records. You need to have a comparison calculation somewhere that says here's what they got paid and here's what they would have got paid under the award. And then you need a clear breakdown of kind of how the salary was calculated and what it's meant to cover. Now those records aren't like audited monthly or quarterly by anybody, but if it's ever challenged by Fair Work, you would need to produce that and say, no, look, we didn't underpay them. We've been keeping these records, and having clean records is obviously going to strengthen your case, and not having clean records will weaken your case. And so you want to be doing those reconciliations regularly on a quarterly basis, for example, and making sure for all employees that you have have those records. But it can be done and is certainly done. Um, so hopefully that answers those questions. Got a lot of questions coming through, so I might keep running through the slides. So let me just flick back and I'll come back to some of these questions. They're good questions. So we've talked a little bit about employment types. Now let's talk about the actual documents that you need. So once you've figured out how you're going to engage someone, whether as an employee or a contractor or an intern, you want to get a document in place, a contract in place to formalize the arrangement. And again, most people will be familiar with employment contracts or contractor agreements. It's not actually a legal requirement that you have a written document. It's just a really, really good idea to show that you're complying with the law. So these are not legally required docs, but every lawyer is going to tell you that you really want to have one. So if you don't have a proper employment contract in place, it's a bit risky. And again, one of the things you just want to make sure is done correct. So what goes in the contract? Well, an employment contract is going to cover what is this person getting paid? What are their leave requirements? And again, this is ticking the box to say we're paying them enough under minimum wage and award requirements. We're paying them. We're going to give you all the leave. If there's a probation period where you can terminate immediately after a short period, you can put that in the contract so it's very clear. It's going to set out IP ownership and confidentiality. So this is going to protect you if the employee has access to valuable IP of yours, documentation, or other original things that you're doing. And if there's confidential information about the business that you don't want them sharing, stealing, giving to competitors, using to set up their own business, the contract is going to make them promise that anything they create is owned by you. And also that they won't use any confidential information of the business for unauthorized purposes. And these clauses are very important. And if they haven't signed a document confirming those things, you could be at risk of those things happening. And then termination rights, making it very clear if something isn't working, in what circumstances can you terminate them immediately and how much notice you have to give. And again, there are laws about termination and the amount of notice that you have to give. But these are reflecting that you are complying with the law, but also giving them notice as to what you might consider a breach of contract. And therefore, that gives you rights under law to do faster terminations, if that makes sense. So, yeah, definitely get an employment contract in place. Full-time and part-time ones are pretty similar. Casual ones are quite different because, as I've already kind of covered, casual employees have quite different legal requirements. So most businesses, we suggest have a full-time, part-time template that they fill in for full-time, part-time employees and a casual template. So 2 documents that you use for different staff types. There are some free ones on Fair Work, but they're not great, to be honest with you, and they're not that employer friendly. And so if you're an employer, again, we recommend that you invest the money to get one properly done for your business. And also the Fair Work ones are obviously not going to consider all of the award requirements for your industry. They're quite generic. So they're better than nothing, but again, worth getting proper lawyers to draft these up for you. And similarly for independent contractor agreements, these ones are not covered by all of these NES modern award entitlements, so they're a bit simpler. They just say what they say. I, the business, engage you, the contractor, to do this for me. I will pay you this much when you invoice me. But you can say the same stuff. I'll own your IP. You got to keep information confidential. And they'll cover what happens if the contractor makes a mistake. Maybe they're liable, whereas an employee, it's difficult to make employees personally liable for things in your business, but you can often do that with contractors. And you can terminate sort of however you want. So there's a lot more flexibility in the independent contractor agreements and a lot less laws that you have to worry about when you're drafting the document. But you still want to get them right. And also, you've got to be aware of that risk of it being considered sham contracting. So again, we generally recommend getting these done properly, or at least checked by a lawyer, to make sure that the way you've designed your contractor agreement isn't risky and increases that risk of it being considered sham contracting. So hopefully that clarifies how the contracts work. I might then, before I move into this section, dive back to a couple of the questions. So Jermaine asked the question, for internships, what if I want to pay them a small wage to compensate them? What if they're students, but the internship is is part of their curriculum. Um, so yeah, if they are um, a student in a course, um, it's interesting because if you pay them a small wage, it it can create an argument that it wasn't part of their course, really. It was actually being they were working for a wage, if that makes sense. You can give oftentimes what people do for students is they'll give them lunch vouchers or other sorts of things, but primarily the internship is framed as part of a course. Once you start paying a wage with super and those things, but if it's below minimum wage, um, it gets a bit risky because again, it looks like this wasn't actually done as part of their course. It was done for an underpaid, employment arrangement, if that makes sense. And so, yeah, it does depend a bit on the circumstances and exactly how you're paying them. But I would say it's usually safer to not mix the two. And if it's going to be a unpaid internship for course credit, you keep it as an unpaid internship for course credit. And if it's going to be a paid internship, you pay them minimum wage and comply with those requirements. And the middle ground would be more giving them, lunch vouchers or other sorts of benefits rather than an actual wage, if that makes sense. So hopefully that answers that question. Um, uh, Jared said, did you say minimum 20 days annual leave for full-time employees? Yes, effectively it's 20 days. Yeah, 4 weeks per year under the Fair Work Act. Um, and sick leave is 10 days per year is paid. And that covers, personal illness or injury, and also covers like caring for an immediate family member is covered by that personal carers leave. Um, Mental health, yes, can be covered. It doesn't need to be formally diagnosed as a mental illness, but you can require a doctor's certificate or some evidence. Employees are allowed to take sick leave for anxiety or stress or burnout. That is allowed. And for minimum wage, does that include super or is that on top? No, super is on top. So the 24.95 per hour minimum wage is base pay only. And super is actually no longer 10%. As of March 2026, it's 11.5% on top of the 24.95 or whatever the wage is, and it's increasing on 1 July to 12%. And that is yes on top um, of that minimum wage. And from what level of engagement does a contract agreement need to be signed if it's only occasional? Um, so the contract agreement, as I mentioned earlier, it's not a legal requirement to have one. It's just a really good idea to have one. And I would recommend to anyone who's engaging contractors, do it from day one. Um, Even if it's for a one-off job, um, it's going to reduce the risk of sham contracting because you'll show exactly what it was. You'll own the IP. It'll reduce disputes around payment. It'll be clear who's liable. Like it's much better to have the contractor agreement in place from day one. If you're thinking, oh no, I have a contractor and I haven't done an agreement yet, it's not the end of the world. You can do an agreement, you can get it signed, you can have an effective date even in the past to get it covered, so you can back fix it or reduce your risk. But best practice um, would be to get that in place from day one. And then another question, are there any stipulations in the law around working from home if employees wish to work from home, but the employer does not allow it? Yeah, so I briefly mentioned that earlier. There is now a requirement in the NES that employers must entertain flexible work requests. It's not for all employees. There has to be a good reason if they want to make the request. Maybe they need to care for someone or there's a disability or, whatever it is. So it can't just be like, I want to, if that makes sense. There has to be a reasonable reason why they're asking for it. If there is a reasonable reason that they're asking for it, you still can refuse if you have reasonable business grounds, i.e., like the requirements of the role make this impossible. But you have to show that you've properly considered it, you've considered alternative, and give written reasons. Otherwise, they can go to Fair Work and say they refused a reasonable request for flexibility. So it's a limited sort of right, but it is there. It's not that anyone can just ask it. There has to be a good reason, and that's kind of specified in the law. And again, it can be refused on reasonable grounds. So hopefully that answers that one. Okay, so let's keep going through tax and superannuation. We have, in addition to the Fair Work requirements, which we just covered on, the minimum wages and the awards and so on. There's another set of laws, the tax and superannuation laws, which are not in the Fair Work Act, which is an employment law. They're in the tax laws, and they also apply, though, to employers around how tax must be handled for your employees, how pay slips and records must be handled, and how superannuation works. So if you are employing a staff member, in addition to having the contract and all of the minimum pay requirements in place, you've got to make sure that in the way that you pay the employee, i.e., you transfer the money from you to their bank accounts, you're doing it in a way that's compliant with the tax laws. So there's a requirement that you withhold the tax, the income tax, that they are going to need to pay the government based on their income level. So all employees have to pay tax on their income, assuming they're above the sort of tax-free threshold. And you handle that for them, usually using the pay-as-you-go system. So if their wage is $50,000 a year and you're paying them monthly, or $120,000 a year, you pay them $1,000 a month. They're going to get less than $1,000 in the bank because a portion of that, let's say 30% or whatever it is, that they would have to pay an income tax, you withhold and you pay that to the government, if that makes sense. So that is important, that you're making sure you're withholding their tax and only paying them their what's called net salary, and then making sure that tax is paid by you to the government. In addition, there's something called fringe benefits tax. It doesn't apply to all businesses, but if you are also on top of like salary, you're giving some other benefits like a company car or a parking space, or you give them entertainment or whatever it is, that's potentially considered part of their income. And so you also have to pay a tax on those non-salary benefits that you've given to an employee. You've got to pay that to the government as well. So you've got to make sure that those are being paid. And again, there can be fines and penalties if they're not paid properly. For employers that have larger payrolls, not relevant for all small businesses, but if your payrolls are above roughly $1 million, it varies by state to state. There's a second tax called payroll tax that the states enforce, which is often a percentage of the total wages that you pay. So that can be another tax for larger employers. And again, we have a lot of clients who start as a small business and then grow, and suddenly they're paying their wage bills over $1 million, and they realize they were meant to pay the New South Wales government this payroll tax thing they hadn't heard of. So worth being aware of if your wage bill is reaching that level. In addition to these tax requirements, you've got to keep records and provide pay slips to employees. That's a record of, here is what you got paid. Here is the breakdown in terms of your salary, the amount of tax that was withheld, the amount of superannuation that was payable. You've got to give it to them within 1 working day of payday. It doesn't have to be physical. It could be electronic. It could be in a system that's made available to them. But even if they're on leave, they've got to be able to get access to the pay slip within 1 working day of payday. And you've got to keep these records of pay slips, and if they're casual, and it's based on time records, you're required to retain them for actually 7 years. In case of dispute, you need to pull out the evidence of what the person was paid. So to handle a lot of this stuff, a lot of small businesses will use, they might engage like a payroll company. People often do bookkeeping and payroll with an external business, and they will often handle the pay as you go for you. They'll handle the pay slips for you, but it costs money, of course. But if you can afford it, that can be a great way to not have to worry as much about the compliance. It's still your responsibility, so you've got to make sure that they're doing it right. So it's worth you being across the laws, but they can handle a lot of the administration. Alternatively, there are softwares if you want to do it yourself. Xero is a common software, and a bunch of other, MyOb is another one, which have software features that are set up to be compliant with Australian law and can help you handle a lot of the way that your payrolls run. So, uh, you know, do consider using a software to handle some of this stuff. You can do it by hand with spreadsheets, but it can be a lot of administration. Um, that can work for small numbers of employees, but most businesses with many employees end up signing up to these softwares so that a lot of it is handled and automatically done. But these are the kinds of requirements. And then finally, and this sort of answered this question earlier, but superannuation is a requirement on top of employees' income. So you've got to, when you pay them, if they're an employee, also pay them superannuation. And that money goes directly from you into their nominated superannuation fund, which they usually give you when they start, as an employee. So normally, if someone's starting with you, you're going to be giving them an employment contract to sign. You're going to be giving them their Fair Work Information Statement and the casual statement if they're casual. And you're going to be giving them a super nomination form to say, where should we pay your super to, if that makes sense. And once you have those, those are the kind of the three documents that often go with an employee offer. So once you have that information, again, every time you're paying them, or you can often do it quarterly, you've got to retain that money and then pay it all into their superannuation. Now that's for employees. Contractors usually, the general position is contractors don't have to be paid superannuation because, again, like I said, they're a separate business. But there is an exception where if a contractor is paid principally for labor, i.e., they're not like a contractor that supplies goods to you, but they're a contractor that's doing work for you of almost employee-like, and they're paid for hours worked. Similar to that sham contracting test that we mentioned earlier, even if they're on paper a contractor, they might be entitled to superannuation on top of their pay as well. And again, it's a very similar test in terms of working out, is this person just a contractor on paper, or are you just trying to avoid paying them super? And if they're treated a lot like an employee, you can have this requirement to pay super. So I just, again, encourage people who are contracting people and hoping that it'll be as simple as paying an invoice. That can totally be true, but if you're really treating them like an employee, you just want to be careful that all of these employee obligations don't fall on you and you find yourself having to back pay things. And again, we provide a lot of advice on this topic when people are thinking of contracting but getting a bit worried about sham contracting, and we can give you some advice as to whether we think it's a high or low risk sort of situation. So I mentioned earlier, yes, the current this is a bit outdated, but the current super is 11.5%, and it's going up to 12% on 1 July 2026. Super does not need to be paid for employees under 18 years who work less than 30 hours in a week. So for any of you that have staff in that category, that's worth being aware of. I can see we got a few more questions. I might just quickly go through these before we get into workplace policies. If a part-time or casual has changes in their working days, do we need to issue a new contract or letter, or does rostering only apply to the casual only? Sometimes it depends on, the employee type. If a part-time team member is changing their agreed regular hours, then yes, you should have a written record of variation. You don't need to redo the whole contract, but you might send them a letter, which they would sign, and which says, as discussed, it's agreed that you're swapping from Monday, Wednesday, Thursday to Tuesday, Wednesday, Thursday, or whatever it is, because the whole basis of a part-time employee is that they have agreed regular hours, days of working. So you don't roster your part-time staff. That's one of the features of part-time staff. They have regular working hours. Casuals is the opposite. They don't have guaranteed hours. And so the starting presumption is that you will be having a roster, and usually under an award there are requirements of you must publish a roster once a fortnight and give them this much notice. But changing the working days through the roster is fine for casuals, but not for part-time staff. It needs to be documented. Um, what are the technical differences between a contractor and a supplier? Um, it's not really a legal term. They're both it's almost a semantic difference. People use them interchangeably, but generally a contractor is understood to be someone who provides labor or services to you, and a supplier is someone who provides goods or package services to you. Yes, people use the terms differently, certainly in, creative industries. Oftentimes, they refer to contractors as suppliers, colloquially. So again, it's not a legal difference, but yeah, I think usually it's understood as contractors more labor and suppliers more, uh, goods or services. But in legal terms, we probably view them both as contractors or contracting parties. Um, What if an outsourced payroll company no longer exists and failed to keep records for their clients for 7 years as required? Yeah, it's your risk. You would probably have a claim against the payroll company to say, you promised you would do this, I'm going to sue you. But if they no longer exist, it's difficult to know who you would make that claim against. Fair Work is going to hold you liable. They'll say, we didn't ask you to use an outsourced payroll company. You should have asked for a backup of the records and so on and so forth. So, um, it is a risk, and you want to make sure that you're on top of that. And if all the records are sitting with the payroll company, you might want to take backups or ask them to provide copies to you. Oftentimes, outsourced payroll companies you'll host the software and they'll have access to it, so it'll still be in your control, and that's how most businesses manage that risk. But it is still you on the hook. Um, okay, I might come back to these questions, conscious of time, so I just want to get through the last few, and then I'll come back to these ones. Workplace policies and procedures. I mentioned earlier, you want to make sure you've got your contracts in place with staff when they start. In addition, it's a good idea to put into place some policies and procedures internally as your workplace grows. Now, again, these aren't required by law, but they help a lot for compliance. One of the most important ones is workplace health and safety. If you are an employer in Australia, you're required by law to provide a healthy and safe working environment. So if you do not provide a safe working environment, you can be liable for providing an unsafe working environment. Now, much of that comes down to, actually, is your workplace safe? Are there exposed nails everyone has to walk through, or is it a safe physical environment? Are there processes and procedures if there's a fire and so on for people to escape an office? Even if people are working flexibly, are they maintaining a flexible home office environment? So these are more practical things than like documents you need to put in place. We do recommend people put into place a document to structure all of the things that they're doing to maintain a safe workplace. And a lot of businesses will put in place a workplace health and safety policy and say we have all of these different procedures that we do as a business to make sure that it's a healthy and safe workplace. If there are issues, any employees welcome to contact this person. We recommend you do X, Y, Z, and there's processes and procedures. And this is going to help promote a culture of safety. If there's ever any claim that you didn't have a safe workplace, it would look really bad if you didn't have a policy in place. Having a policy in place is great as a first step, and then you can train employees on your work health and safety policies and just help promote this culture of safety that's going to reduce the risk of something going wrong, help show compliance as well, and very important to do. You also have a requirement to pay workers' compensation insurance if you have employees. It's a required insurance. Many business insurances are optional, but just a good idea. But workers' comp is a legal requirement that you have in place. So you also want to get on top of that once you start hiring staff. And again, most insurers will sort that out for you. You can just get in touch. They'll ask you some questions about how many employees you have, and then each year they'll issue you the bill. But if someone is injured at work, they could potentially have a claim against your business, and to protect the employee, you may need to get insurance to pay for it if you don't have enough money. So that's why you want to be having that insurance in place. In addition, we also recommend businesses have a general staff handbook, which is like a suite of policies and procedures, which cover other matters: workplace discrimination policy, sexual harassment policy, workplace bullying policy. Outside the Fair Work Act, or in some cases within it, there's a suite of other laws, there's like the Discrimination Act, and so on, that apply to employers to make sure that their workplace is not promoting a culture that enables these things to occur. Now, again, a lot of that's going to come down to how you run the business and making sure that you're running a healthy workplace and a safe workplace. But having the policies and procedures in place are great evidence that you are doing that, and a great way to show, no, look, we have all of these policies and procedures, we train staff on them, and if something goes wrong in the business, it looks much more like a single bad actor than necessarily liability resting with the business. So it's best practice to have all these policies in place. They're not a legal requirement, but we do recommend that everyone does it. And certainly at Sprintlaw, we have a big set of policies that we train all of our staff on, and that is best practice. So that's most of the content. I'll just quickly cover this closing the loopholes law, which covers some big changes in the last couple of years, and then I'll answer some questions. I know we're at time. I'll go a little bit over. So for those that want to stick around and answer it, but for those dropping off, I hope you found this useful. And there will be a recording published on YouTube shortly after if you want to watch anything back. So just on these closing the loopholes laws, these laws were rolled out over the last 2 years. And as I mentioned earlier, there were some pretty big changes to um, business law, and in particular, those affecting small businesses, which some of which we covered, but some of which are quite specific and sit on top of a lot of the legal requirements. So one, which I think is the number one thing to call out for all small businesses, is wage theft is now has criminal liability. So we talked a lot about how it can be a little complicated to work out how much you need to pay someone. You've not only got to figure out the minimum wage, you've also got to be aware of their award requirements, their overtime. You don't want to have people who are not getting paid super. So there's a bunch of boxes you have to tick around making sure people get paid correctly. And before, if you breach those requirements, you could be liable for back pay or you could be fined. Now the stakes are much higher. Wage theft, as is now the term that they're using to describe this. If you are not paying your employees in accordance with the law, then you're stealing their wages. It's wage theft, and there's criminal liability. Now, in business, as someone running a business, it's very rare that you can be criminally liable unless you're committing, fraud. But usually there's civil liability, you can be sued, but it doesn't go criminal. But in the case of underpaying employees deliberately, you knew you were underpaying them and you were still doing it. You knew you weren't giving them super and you were still doing it. If that can be shown, then there can be you could be prosecuted. So and it's targeted at studies that were coming out showing, particularly in hospitality businesses, there were lots and lots of cash in hand arrangements, people being underpaid, and people not knowing their rights, and massive flagrant breaches of workplace laws. And so get on top of your wage payments is the key message. There is a small business process where if you find out that someone was accidentally underpaid or there was some administrative issues, it wasn't deliberate, reckless underpayment. There's a compliance code that they've issued where if you follow the steps in there to rectify things promptly, and as long as you've complied with that and sort of done your best, and it's not intentional and so on, it cannot be referred for criminal prosecution. So worth everyone having a look at that as well. And if you make mistakes do happen in most businesses. It's very unlikely that will cause you to have criminal liability, particularly if you follow the code. So you don't need to be terrified that if there's one administrative error, you're going to go to prison. But it is the case that if you are running a organization that is deliberately engaging in underpayment, then there's big risks. There's a few other things. Small business redundancies don't have to be paid. Do have to be paid. Sorry, in the case where a business is shutting down. I won't go through all of these because they're a bit specific, but again, I'll circulate these slides just in the interest of time. One of the ones I wanted to mention is there's something called the right to disconnect, which people may have seen in the news, where employees can now refuse contact from employers outside their usual working hours. And this got a lot of media attention because some jobs do require people to employers to contact employees after they've left work, or where did you put this thing, or I've got a quick question for tomorrow, etc. And this right to disconnect seems on the surface to make that unlawful. Um, there are some laws now that restrict these rights. It's not as, in my view, as aggressive as it was portrayed in the media. So you are able, as an employer, if you have a good reason, to contact an employee out of work hours, and you can even make it part of their job if there's a good reason, operational reason why you always need to be able to speak to someone at various times. It's just unreasonable contact, and not giving someone a promotion because they didn't work late at night when it wasn't really part of their job or required for their job, and these sorts of things. Discrimination on this basis is not allowed. And even if someone raises a complaint about it, there's a process where they have to speak to the employer first before they can raise it with Fair Work. What I would suggest again is having a policy in place around when you can and can't contact people, and if you want to be able to contact staff outside of working hours, explain to them why, document it, and communicate it to them. And in most cases, it will be okay for you to then do that. This is more targeted at a really flagrant out of work contact as a requirement. Essentially, not paying people for additional work, if that makes sense, is really what they're going after there. And the last thing I just want to mention, which is the last one on this slide, is there are now bigger penalties for workplace breaches in general. So we covered a lot of laws in this presentation. We've covered some new laws. Now, you might think, okay, this sounds like a lot of laws. I'm sure businesses are breaching them everywhere. And again, some studies came out in the last 5 years showing that breaches of the employment laws were very common, particularly amongst small businesses. But Fair Work wasn't enforcing these laws, and so people were just breaching them and not getting caught. What's changed in the last 2 years is there's a lot more budget has gone to Fair Work to increase enforcement action, including against small businesses. The penalties have increased to make the stakes higher. They're obviously making wage theft criminal. They're really cracking down on people not complying with employment laws. And so if you think I've been doing this for years, I never got caught, I'm fine. The future is, in my view, unlikely to resemble the past, and you really want to make sure that you are complying with the laws because the consequences can be serious, and the regulator is starting to take a lot more action. And in the last year, we've already seen many Fair Work cases affecting small businesses where these new laws have been enforced. So there's no better time than the present to get on top of this stuff, is what I'm trying to say. So hopefully that was helpful, and I'm just going to answer these Q&A questions for a few minutes. So we have one in here. If a contractor has an ABM and we pay his on an invoice, we charge an hourly rate, do we pay super, and he follows instructions of us, does it deemed employee for super and payroll tax purposes? Look, it's difficult to answer that question. That's the question that you're asking is probably the kind of thing we provide legal advice on, because it depends on a lot of the circumstances of the engagement, what your business does, what this role is, how long it's been there. So I can't really answer the question. I can say from what you've shared, the fact that it's hourly and if he's working completely under your instruction, there is some risk there that it could be a deemed employee, at which point, yes, super and payroll tax become payable. There may be ways to structure his contract if you have a good contractor agreement and get some legal advice to reduce that risk, potentially change the way this person's paid, change what you mean by instruction, and so on. So there's some risk there, is my answer to basically that question. But whether this person, I can't really tell you from that information as to yes or no, whether they are a deemed employee or not. Jermaine's asked, does that mean you need agreements with every supplier? So I guess my answer to that is there's no, as I said before, there's no legal requirement to have contractor or supplier agreements in most cases. It's just a really good idea for compliance and reducing risk and so on. I would suggest for any person that's doing labor-based work for your business, every single one you should have an agreement with. Mostly, often what we do at Sprintlaw is we'll prepare a template supplier agreement or a template contractor agreement, and then businesses will just require people to sign that before they work with them. And so it's a sort of one-off cost to get the template, and then you just get it signed. And just having that can really reduce your risk a lot in many ways. You don't need one, but it is a really good idea. And certainly at Sprintlaw, every supplier we work with, we're going to sign an agreement with them. Sometimes they'll bring their own agreement and we'll just check it and review it. But if they don't have one, we're going to be requiring that they sign ours. And then we got one question here. Lately, employment is moving to 2 years contract working full time with a view to extend. Is that considered full time, but with a set possible termination rate? Yeah. So there is a type of employment that I didn't fully cover in this presentation, which is called a fixed term contract. So what you just described there would be considered a um, full-time fixed term contract. Um, the During the time that they are a full-time employee, they're entitled to all of the same rights as a full-time employee in terms of annual leave and sick leave and minimum wages and whatever the award requirements are. So they're essentially a full-time employee. But the pre-agreed end date um, uh, is um, is basically a protection against redundancy risks and so on and unfair dismissals, because when the employment ends, the employer doesn't necessarily have an obligation to extend. Now, if you included in the contract, which you half mentioned in this question, a right to extend, like an option to extend, now there's actually a big change in the 2023 closing the loopholes laws that doesn't allow that. Fixed term contracts are now restricted to 2 years total, which is why you might have seen this trend. Um, uh, the If you do extend it, then the contract may be treated as basically an ongoing permanent employment. And so usually after that initial 2 year period, it either needs to end or become permanent, if that makes sense. And you can't just have like an option to extend in the agreement. So hopefully that makes some sense. But yeah, that's a good question. Fantastic. Well, I hope people enjoyed the webinar. We do these every month. So I think we've got one coming up next month as well. So please come along. Otherwise, it was great to present to you all and look forward to seeing you next time. Thanks so much.